Hey guys, my name is Nicolette Mashile. I am also known as The Financial Bunny. Welcome to The Financial Bunny TV. So today I want to talk about what do you do in a case where you find out that you've just bought a property, it's now been transferred to your name, but the municipality comes and says to you, well, this specific property has historical municipal debt. In other words, the previous seller or the previous seller has not been paying the municipal rate. What do you do in such a case? Now remember, none of my videos constitute as financial advice. If you are, however, looking for financial advice, please speak to somebody who is certified and registered with the FSCA. In this specific case, also please consult with a lawyer, a registered lawyer, so that they can give you legal advice, because for the sake of this video, I'm only giving you information so that you can start sussing out what is actually the situation with your specific situation, right? So on Monday, I got a DM from a young lady, a young lady that I'm very proud of, because I've helped her. Her and her sister were trying to buy a property, I think a year ago, and they were kind of asking me, what is the process? How do you follow the process? What does this mean? What does that mean? I always chuckle about them, because one of the things she had actually asked me was if they can apply for more money than the property that they want to purchase, and then use that money as part of upgrading their mother's home. And I was like, oh, unfortunately, with the new financial system, you actually have to give an offer to purchase before you can apply for you have to sign an offer to purchase by the time you are applying for a home loan, because the bank will only borrow you however much the property that you're trying to buy actually is. So in the olden days, you could borrow more than what you were trying to buy. And that's really one of the reasons why we had a financial crisis in 2008. But let's put that on the side. So she sent me a DM and she was like, hey, Nicolette, so I've got this problem. The property I was telling you about, well, it's been transferred. So yay! However, we had a nasty surprise from the municipality. They came, they took the meter, they said, yay, this person that is living in this property does not pay their municipal rates. And they've basically been living off, I don't know what they had done there. Maybe they had bridged, because I don't think it was a metered or, those prepaid meter electricity. So it's probably electricity from the government, a sewage service from the government, and of course water from the government, which means that you've got to pay the municipal rate. So clearly the previous seller was not paying. So the first thing obviously I asked is, number one, was there a clearance certificate? Because when you are buying a property, one of the things that the seller needs to furnish you with is what we call a clearance certificate from the municipality. In actual fact, there is a standard that they should give you a clearance certificate and also prove that they've paid in advance. Because remember, there will be months where this thing has now been lodged at the deeds office. No one's really, the ownership of the property is still sitting with the seller, but it's kind of being transferred to your name. So you don't really, some sellers might not believe that they are responsible for paying for the municipal rates. So essentially, there is a standard that the seller should get a clearance certificate through their conveyancer, the conveyancing lawyer. That's their responsibility to go and get a clearance certificate, make sure that the figures are correct, but also the seller must pay in advance. So that little kitty that sits with the conveyancing officer or conveyancing lawyer, they should be using that to pay upfront for those months where there is a lodgement that has happened but the transfer is not taken place. A buyer is not responsible for any municipal rates up until the property is actually transferred into their name and they start usage of those services, right? So in other words, any historical municipal debt you should not be liable to pay for. Now, in the olden days, there used to be this automatic thing that municipalities do where they just make the new buyer liable for municipal rates that were, that were actually in effect even before the transfer actually took place. But we've got an interesting case, and in South Africa, we believe in case law. We have an interesting case where it's Jordan versus Tshwane municipality, city of Tshwane municipality versus Jordan, or it's the other way around, Jordan versus city of Tshwane municipality. I think Jordan was the first applicant, and there was a second applicant called New Ventures, which is a company, I think, and then several other applicants. But basically what the court ruled there is that you cannot automatically hold the new buyer liable of historic municipal debt that happened before the transfer actually took place. Now, obviously, people will say, but what if it is in the actual sale agreement or in the offer to purchase that the buyer or the seller knew about those municipal debt and has put it in the offer to purchase or in the sale agreement, and the buyer then signed and agreed to it? Well, in that case, yes, then the buyer will be liable because the buyer knew that this municipal debt actually existed and they agreed as part of their offer to purchase that property. So perhaps maybe the seller worked it out by reducing the selling price or whatever. So we don't really know what would be the circumstances in that regard. But if it is in the sale agreement or the offer to purchase, then yes, the buyer is liable, right? But it is not an automatic that the buyer just becomes liable because they've now bought this new property. You are only liable as a new buyer for any cost of services and municipal rates that happen after transfer, or rather that are come into effect after transfer. Now, there's a question that people ask, and it's this clause that is in your offer to purchase that sometimes it's there, sometimes it's not there, and it's called voetstoots. Basically, the buyer buys as is and seller sells as is. So that, my friends, is only valid for structural, plumbing, so it is the actual property that you are buying as is. A seller cannot think they are clever and try to squeeze in historic municipal debt. That is unfair. And in actual fact, if the seller knew about that municipal debt and did not inform you as the new buyer or their conveyancing lawyer, then they are misrepresenting the actual offer that they're putting on the table, because you are not only putting a property on the table, you are also putting somebody clearing your existing debt. So it would be misrepresentation of the actual offer that the seller is putting on the table. Now, in this specific case, one of the first thing I asked the young lady is, what was in the offer to purchase? And she mentioned that the seller said, no, I sold this thing voetstoots. Well, sorry for you, Miss Seller. Voetstoots does not include municipal debt. Voetstoots is talking about latent defects, and sometimes I think it's latent and patent defects. That's what it includes. It does not include municipal debt, okay? It includes structural, plumbing. There were cracks on the walls, and the person who came to view the house saw the cracks on the walls and still wanted the property as is. Or maybe they negotiated a rate lower and said, hey, actually the kitchen is a bit sus, so let us bring down the selling price by 100,000 because we will use the 100,000 to renovate the kitchen. And then patent sometimes is maybe you've got mold in the walls and you can't see it until maybe it rains. You know what I mean? Like, for instance, I had this thing where I have this, I don't know what it's called, where they put in glass where they're supposed to be wall, right? So I have that, and it's a beautiful feature of my house. However, the problem is, if it rains, it leaks through the walls. The water comes running down like a rainfall. Now, of course, the seller, if it had not rained in all the time that they lived here, they wouldn't have known that, right? So they sold me the house voetstoots, but that was something that I could get recourse on, and the seller actually sent me the guarantee that they've got with the guys that came and did the, what is it called? The ceiling, where they seal the ceiling. I can't remember what it's called, but basically they actually kind of knew about it because they got a service to do it. Luckily, that service had a guarantee, and I was able to call back those same guys that did the job for them to come and redo it. The sealing the ceiling. I don't know what the service is actually called. Nonetheless, so I said to her, look, voetstoots, I don't think is going to work for the seller here, but I do think that you need to get a lawyer so that they can assist you with whatever's happening. The second part is, did they give you guys a clearance certificate for the municipality? She says, yes, they did. I said, okay, perfect. If they gave you a clearance certificate, then you need to put pressure on the conveyancing lawyer, because how did the conveyancing lawyer not recognize that that clearance certificate is either invalid, it's a fake clearance certificate, or pick up the phone and actually validate it with the municipality. Because this young lady actually goes on to tell me that she went to the city of Johannesburg municipality, and somebody there told her, and I stand to be corrected on this, and this is me literally quoting what this young lady said, that there are people have connections at the municipality. So if they're looking for a quick clearance certificate, they can get it. Literally, they can pay and they can get it. I mean, we live in South Africa. Anything is possible here. But at the end of the day, a conveyancing lawyer's responsibility is to make sure that that clearance certificate is valid, it is correct, and has the correct figures. So in other words, you can put pressure, even on the conveyancer, to say, how did you guys get duped with this clearance certificate? Please call your seller and tell your seller that they are liable to pay for these fees. So that's also something else that I actually had picked up there to say, no man, something is actually wrong here. So I had suggested to her that she should get a lawyer and hold both the seller and the conveyancing lawyer accountable, because they both have a role that they need to play in this specific case, in terms of this clearance certificate that has been filed as part of the transferring process. So, in other words, or rather to summarize, if you find yourself with a situation, number one, please go and read up on the case. It's Jordan versus City of Tshwane Municipality. This Jordan was the first applicant. Then there was New Ventures as second applicant. There's quite a number of applicants there. Read that case because it will give you a little bit of clarity in terms of what the court ruled on historical municipal date. It said that a new buyer cannot automatically be held liable to pay for municipal debt that was incurred before the transfer actually took place. The second thing is, don't let anybody dupe you with the whole voetstoots clause. Voetstoots does not take municipal debt into regard. It is speaking to structural defects. It's speaking to defects that maybe are not seen with the naked eye but exist. So something like, even when you've got termites in your wood, maybe you don't see it because the termites are still nesting in there and they're still laying eggs, but then you find out about it at a later stage. So things like that, right? And then the last thing is to make sure that that clearance certificate is actually valid. And please, 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 if your conveyancing lawyer can see that the transfer is going to take a little bit of time, they need to make sure that the seller is actually paying their municipal rates up until the last day of when the transfer then gets moved from them to you as the new buyer. Anyway, I'm literally just giving you this information so that you are not caught off guard, and it's not a big shock and a surprise to you if you find out that, the property has historic municipal debt. I will leave it there. Thank you very much. I'll see you guys on the next one. Mwah.